Good evening, everyone, and welcome again to another session this week of How to Write a Tax-Efficient Will with me, Deborah Bowers. Today, we shall be discussing, are you avoiding writing a will? Because there are so many people who don't believe they should write a will. They keep telling themselves, oh, I don't have anything to pass on. I don't really have much value. It really doesn't matter. I'll leave it to the Most High to take care of, and they'll just like, I came in naked, I will just go and it doesn't matter. My family will sort it out when I'm gone. And today I want to persuade you why you should not take that approach and you should write a will, because a will is very simple to write and anyone can write a will. So before we go any further, let me introduce myself. I am Deborah Bowers. I am a STEP certified advanced will writer. I'm also a solicitor of England and Wales. And I practice GDPR, so I'm a GDPR practitioner, certified on the CIPPE, CIPM, and I'm also the author of How to Write a Tax-Efficient Will. This is a book as well as a course. So you can either get the book off Amazon or you can get a copy of the course. The disclaimer which I'm going to make here tonight is that this is a general discussion. Whatever I say here tonight needs to be taken as not as legal advice, not as financial advice, not as investment advice. It will not form a lawyer-client relationship between me and you. It is just highlighting things that you need to consider and think about when writing your will, or when thinking that, you really don't need a will. So we discuss on this platform, wills and lasting powers of attorney. Now, as I said earlier, the main thrust of tonight's discussion is whether or not you, as a person or someone you know, is avoiding writing a will. And in particular, I would like to discuss with you how you could be a secret millionaire. And I know you won't believe me, but I would like to share a story with you as we discuss this aspect tonight. And the reasons why I would say to you that you need to write a will is because you could be a secret millionaire. Also because you care about your loved ones and you don't want to leave them hanging. And because you won't like the outcomes that might come out of you not actually writing a will. And as I said previously, you never know what your net worth is. So you might be a secret millionaire. And the story that I want to share with you tonight is very personal to me. And but it illustrates how you or anyone who is thinking, oh, I don't need a will, I don't have anything, could really be a secret millionaire. And this family is personal to me because it relates to my own family circumstances. Because I came from a family which was neither rich nor poor. My parents were very hardworking people. They were doing their best to keep food on the table for a family of 12. We had a home, and my parents owned the home, and we also owned the land upon which it stood. But can you imagine trying to divide a small home, an average size home, amongst 12 kids? I mean, the amount that each child would get would be very small. So they did not believe that they had anything to pass on, and so they did not write a will. But one day, there were 3 things which happened which changed the course of our lives. Firstly, my dad's uncle, he died leaving a lot of property, and that property passed backwards to my father because he had no one who was in his line, like a child, to pass it on to. The law was not going to allow him to pass it on to any illegitimate children. And the property actually passed backwards to my dad. The second thing which happened was that my dad's brother, he had no kids, he had no wife, and he too passed. And once again, the property that he owned passed backwards to my dad. And as happens to all of us, finally, my parents, my mom and dad, they both passed away. And this meant when that property had passed backwards on 2 occasions, my father was now considered to be a rich man. He was not super rich, but he was very well off. He was at least in the millionaire category. But what was the problem? The problem was they passed and they still had not written a will. They had no will, and now they owned more assets than they had ever anticipated owning. And what do you think happened? The infighting among siblings began. Who was going to pay for the intestacy provisions? Who was going to pay the lawyers to sort that out? How were the assets going to be divided? Suddenly, the rule of equal distribution simply vanished. It doesn't apply anymore. And who is going to reimburse that person? Who is going to refund the cost that the money they've spent on going through the legal process? You know, it all was very, very awful. And it destroyed what had been a beautiful family, a place where I had been happy and very safe as a child. From that moment on, I was determined to get my own house in order because I was not going to let those circumstances arise within my family, my personal family. I saw the consequences of how thinking small, that a will was not necessary, had destroyed us instead of allowing us to reap the benefits of our inheritance. And we spent so much on legal fees and infighting when that could have all been avoided. From that day, I made it my mission to help as many people as possible write their will, whatever their circumstances. Because I knew from personal experience, and I know now, that a person can become a secret millionaire. You never know where your assets are going to arise from. This led to me training as a solicitor and even taking a master's in the law of trust. I also became a STEP certified advanced will writer. And now I have written a book, How to Write a Tax Efficient Will, to help others, as well as creating a course by the same name, How to Write a Tax Efficient Will. In that course, you can take your time, go through it. It will also help you with lots of sample wills so that at the end, you too can have a valid will. So if you are still avoiding writing a will and thinking that it's not necessary, I hope this little story will help you change your mindset, because there are countless benefits of writing a will, whatever your circumstances. And I'd like to thank all of you who have joined me here tonight, because I hope you will be able to share this with friends, family who think that, oh, a will is not necessary. So to move on from that story, I just want to show you what would happen to your finances or your assets if you do not write a will here in the UK. And remember, before we even get to this, we have to deal with the issues which I mentioned. Who will take the lead to apply for the intestacy? How will that person be reimbursed for the expense that they have put into it? And who will be appointed executors, trustees? If you had written a will, you would have had those in place. And so no one would have to be thinking who would be the executors, who would be the trustees, unless those persons have died. And you could have also appointed replacements. So you see the amount of issues that you avoid when you have simply written a will. Now, on the screen right now is the distribution of your estate should you pass in the UK without writing a will. And you can always verify that information by going on to .gov.uk intestacy. It is called an intestacy when you have not written a will and your family has to figure it out. So I will go through each of those little segments of this pie to explain exactly what happens in the UK when you don't have a will. So it all depends on your circumstances when you pass. If you are married with children, then the first £270,000 and all your personal possessions goes to your spouse. Because you've got a wife, and if that person is still alive, those assets go to the wife or the husband. 50% of the balance is divided equally between the children, and the remaining 50% is what is held on trust for your spouse during their lifetime. And once your spouse passes, that 50% that was being held for them then goes to the children. It's divided amongst the children. And you see here, there is something called divided equally between the children. And these are things when people have spent their money to do all the paperwork, all the legwork, all the legal stuff. They're like, I should get a greater share. But if you had written a will, all that wrangling would not have been necessary. Your will could have catered for the distribution of the assets. So if your circumstances are different and you have got a spouse, but you have no children. So we just looked at if you had a spouse and you had children, how the assets would be divided. But if you have a spouse, but you have no children, all goes to your spouse. If you have no surviving parents, siblings, nephews, and nieces. So in my dad's case, his parents had passed. And so the property went backwards to him so that it went not to siblings because the siblings had passed for my uncle, but it went to the nieces and nephews. And he only had nephews, my father being a nephew. So his property went to my dad. But if any of the other people mentioned they had survived, then they too would have benefited. So if you have any surviving parent, siblings, nephew, or nieces, if there are any of those, then 450,000 plus all your personal belongings, and 50% of the remainder goes to that surviving relative. The remaining 50%, if you have any parent or any of those persons, 450,000 plus all personal belongings, and 50% of the balance goes to them, and the remainder goes to your surviving relatives. So parents first, siblings second, nieces and nephews for third. Okay? So you can see here that sometimes these are not desirable outcomes. You may not want that, but this is what the law of the UK would say that needs to happen. Okay, but if you had written a will, you could have distributed your assets however else you wanted it. So have you got children but no spouse? Because sometimes there are lots of single parent families, and your estate will be divided equally between your children. And you see the use of that word equally between the children. And most people want the assets to be divided equally between the children, unless you have had a very stormy relationship with a child. But then again, someone has to come forward, because there is no will, to take responsibility to pay for the paperwork to be resolved. And that person will want their money back. They will not want to see other people getting an equal share, and they were the ones who paid and spent all their money. So if you had written a will, you would have said who the trustees will be, who the executors will be, who the trustees will be, and there is always reimbursement for executors and trustees, and in any event that comes out of your estate. So it's automatic. It reduces the friction within the family, because nobody likes to know they've spent their money and how are they going to get it back? Are they going to fight with their siblings to get it back, or does the law protect them? So are you likely to leave no spouse or issue no children? So your assets are divided in the following order. You have no spouse, you left no children. Your assets will go to your parents if your parents are still alive. If your parents are no longer with us, then the assets will go to siblings or their children, your brothers and sisters, or the children of your brothers and sisters. So that's the nieces and nephews. And if there are none of those, if your grandparents are still around, the assets will go to them, or then it will go to aunts and uncles. So this is the order of distribution here in the UK when you have no will. And have you no surviving relatives? If they can't find anyone who is related to you in the list we just mentioned, then your estate goes to the Crown. So the Crown gets everything you've worked for. And how much of an effort are they really going to make to find any surviving relative of yours that you probably would have liked to benefit if you had written a will? But they must make a reasonable effort to find any surviving relatives. And if no one comes forward, or they can't find anyone because they live abroad or elsewhere, and no one's going to look underneath the stones to find your relatives, then the assets go to the Crown. And there are many assets. There is a list with assets which have not been claimed. And you can see people's assets just going to the Crown because they've died here. Their families are over in other countries. Their family never kept in touch with them. They don't even know that they're dead, or they know that they're dead, but then they don't realize that they don't have any will and that they have not distributed their assets. The Crown's not going to go all over the world to look for their relatives, and the assets simply go to the Crown. So this was the discussion for this evening. Of course, you are welcome to get this special offer that I have now on the actual course, How to Write a Tax Efficient Will. I've got a 50% discount on the course just for the next, from tonight, Wednesday to Monday, I believe. So if you want to take the course, you can take the course and work your way through How to Write a Tax Efficient Will. Alternatively, you can purchase the book and go through it. It will also assist you. The book is available on amazon.co.uk by the same name, How to Write a Tax Efficient Will, or you can call me personally to assist you with writing your will. And that's a private discussion between me and you, and getting your will done, and any lasting powers of attorney you may need to have in place. But this discount, this special offer is limited. It should be £48.50. It's a very limited offer, just for a very short period of time. So you can secure your copy of the course or purchase the course at bowersdeborah.mastermind.com/masterminds 36966. I hope you can see the course and the details on the screen right now. I shall leave it for a while as we ask any questions which may be of concern to you from what I have discussed tonight. So you can unmute yourselves now and join the conversation if there are any questions you would like to ask. I'm happy to answer them.
Hi, Deborah. Can you hear me?
Yes, I can hear you. Renata, how are you?
I'm good.
Thank you for joining me tonight. It's a pleasure to have you.
Yeah, what I wanted to ask was about trusts. Because I've just been looking into trusts, about living trusts and
yes,
other trusts. So that is what I'm really interested in putting my assets in a trust.
Yes. Okay, well, let me see. I am not in relation to will writing, wills and lasting powers of attorney. These are unregulated by the Law Society, and I can give advice in relation to that. But in relation to trust, I cannot give you advice. So whatever I say to you now, simply keep it in mind whilst you go and look for other advice. I'm only giving you advice based on my legal knowledge. Now, when you're putting, you can't put your assets into trust. These are called relevant property trust. But what you must always remember is that a relevant property trust, you must transfer the asset into the relevant property trust. Now, you can only transfer something which you own. If you have a mortgage on that property, it is not considered a property which you own because the bank is the other owner. So consider whether or not the assets which you intend to put into the trust are assets which you own outright.
Okay.
So you set up the trust and then you transfer the assets into the trust. But it must be assets which you own outright. It doesn't belong to the bank. Now, if you want to put your assets, if you have mortgages on your property, what you can do is set up a trust within your will so that your executors and trustees can deal with the bank after you have passed, because there's a mortgage to be settled. So they can either take over the mortgage or they can settle the mortgage with the bank. So as I said to you, when you go to speak with someone, can have those two thoughts in mind. Is the assets you want to put into the relevant property trust, which pays less tax than the 40% inheritance tax? Do you own that asset outright? Or is this an asset that you have a mortgage on? Because once you have set up the trust, you will have to transfer the asset into the trust, and it must be a trust that an asset that you actually own.
Outright. And how much you said about the 40%
inheritance tax?
So how much do you pay? What are the taxes on trusts? The amount? As
I said, I cannot give you legal advice on that, but I would say to you, go on gov.uk. The trusts are taxed every 10 years. So I'm saying things to you, but it can't be taken as legal advice.
Yeah.
Trusts are taxed every 10 years. The tax is usually about 4.25%. And you have to pay to put your assets into the trust, usually 20%, and to take assets out of the trust. But you should go on gov.uk to get some more information, because as I said, I am not giving trust and advice. You know, I gave you a disclosure at the beginning, but I can only raise things that you need to consider and tell you where you can go to look for some more information, or equip you with a few ideas for when you go to speak with someone who deals in such matters.
Okay.
I hope this has been helpful.
Yeah, very helpful.
Any other questions? Well, I won't keep you much further. I'm grateful to you, Renata, for asking those questions. These are things that are of concern to many people. And I hope that the information or what I have discussed may be of assistance to them, or they will consider such things. Because if your property is in a trust, one of the things that you can benefit from is that when it comes to care, personal care, if your property is in a trust, it's not in your name. So it prohibits anyone from taking that property to use the value of it for your care. And there are lawyers who specialize in that. But I can only raise those things with you, but I cannot give you legal advice or form any legal relationship with you from saying what I'm saying. It is something that you need to discuss with someone who is regulated by the Law Society to give that type of advice.
Okay.
Yes.
Okay.
All right. And I'd like to thank you all for attending this evening.
Can I ask one more question?
Of course.
How long is the course that you're running? How long is the course for?
You have lifelong access to the course. Lifelong access. You do it in your own time. It's an online course. You do it in your own time. So if you come home this evening and you want to listen to module 1, it has 28 sessions or 29 sessions on 11 modules. And they're just snippets, like a 5-minute chat, and going through the wording with you of how to write what you want to write and why we write it that way, so that you can actually have a will, a valid will at the end of the day. Yes. But you have lifelong access, so you can take as long as you want. If there are any updates, I will put that information there as well. And you don't have to pay anything more. It's just a one-off payment.
Okay.
And you do it at your own pace.
Okay. So, could you have the book and also do the course?
Oh, yes, you can get the book.
Do the two together.
Yes, the book is only $14.99 on Amazon. The course is like a talking book.
Okay.
But it actually takes the areas that you need to focus on to get where you want to get and talk you through them. If you listen to the audiobook, I guess it's a talking book.
Yes,
but the book, you will have to read it and go through. But on the course, I have videos, just as I'm doing here right now, explaining each little section. But having the book and the course is a good idea. Okay. As a matter of fact, if you were to buy on this, because you have attended, if you were to purchase the course, I will give you a free book.
Oh, okay. Well,
the book is on me. Yes, the book is on me. Just send me your proof of purchase and address and the book, and a signed copy at that.
Thank you. Okay, I will do that more tonight. Than welcome.
Yes. So the book is on me. Just send me your details. You have my phone number. Just send it to me on WhatsApp, and send me your address, and I will send you a signed copy of the book. It's on me. Okay, thank you. Okay, thank you very much. And let me know if you need any help as you go through the course. Let me know, because with the book and the course, I can't see you getting it wrong. You are well on your way to becoming a master at helping other people as well. Okay. And it's only for a very short time. That's why I have it on for only a very short time at $48.50. Okay, I'm going to go on now and register for the course. Yes, so unless anyone else has any questions, any other questions? Okay, so if you have no further questions, I will stop the recording right now. But I now owe Renata one signed copy of the book. If any of you wish at any point to ask me to send you a signed copy of my book, I'd be more than happy to do so. And we can arrange the payment therefore, but Renata does not need to pay because she has purchased the course. Thank you ever so much, Renata. Okay, well, I'll stop the recording now and I'll say good night to all of you. Do have a pleasant evening and thank you for joining me. Remember, these sessions are every Wednesday at 8 p.m. It's all free and we are discussing something wonderful. If you have missed any other session, please just go on my YouTube channel and it will be made available to you. Okay, good night and have a great evening. Bye-bye.
Thank you.
You're
Bye. Bye-bye.
welcome. Bye-bye.